Good afternoon. It is Tuesday, November 18th. If you saw my prior video, I did a full reading of HR 4405 or the Epstein Files Transparency Act. And in this video, I'm going to actually break down into simple language what that bill says. This is not legal advice. I'm not a lawyer and I'm not analyzing the bill. I'm simply going to break it down into easy to understand common language for those of you who maybe have difficulty reading a really dense piece of political or governmental legislation. So let's just jump into it. So this is HR 4405. This bill would force the U.S. Attorney General to release all government documents related to Jeffrey Epstein. And it was introduced in the House of Representatives on July 15th, 2025. Section 1, short title. The name of this bill can be referred to as the Epstein Files Transparency Act. Section 2, release of documents relating to Jeffrey Epstein. A, what must be released? Within 30 days after this bill becomes law, the Attorney General must make public, online and easy to find, all unclassified records the Department of Justice has about 1. Jeffrey Epstein, including any investigations, criminal cases, or issues related to his time in custody. 2. Ghislaine Maxwell. 3. Flight logs and travel records for any plane, boat, or vehicle Epstein owned or used or that was used by any of his connected businesses. This includes passenger lists, schedules, pilot notes, and custom or immigration documents. 4. Any people, including government officials, who are named in connection with Epstein's crimes, civil lawsuits, agreements not to prosecute, or investigations. 5. Any organizations, so businesses, nonprofits, schools, or government groups that had known or suspected connections to Epstein's trafficking or money networks. 6. Any immunity deals or plea agreements that involve Epstein or anyone associated with him. 7. Internal DOJ communications, such as emails, memos, notes about decisions to charge or not charge Epstein or his associates. 8. Any communications or documents about destroying, deleting, altering, losing, or hiding materials connected to Epstein, his associates, his detention, his death, or any investigation. And 9. All records about Epstein's time in detention and his death, such as reports, interviews, medical examiner files, autopsy reports, and written explanations of what happened. And B. Reasons they cannot use to hide information in these files. The government is not allowed to hide, delay, or edit any records just because releasing them would embarrass someone, harm someone's reputation, or be politically sensitive, even if the person is a government official, a public figure, celebrity, or a foreign leader. C. Reasons the Attorney General can withhold information from the files. The Attorney General is allowed to hide or edit parts of records only if they contain the following. 1. Private personal information about victims, including medical or similarly sensitive files. 2. Child SAM. 3. Information that would harm an ongoing investigation or active court case. These withholdings must be limited and temporary. 4. Graphic images showing death, physical abuse, or injury. 5. Information that is properly classified or kept secret under a lawful national security rule. And then there are some extra rules that are listed in the language of the bill. So basically, every time something is redacted, the government must publish a written explanation in the Federal Register and then send that to Congress. If information is classified, the Attorney General must declassify as much of it as possible following those prior outlined expectations. If something cannot be declassified for national security reasons, the Attorney General must release a summary of why it was withheld and what was withheld and put it on file. And any decision to classify Epstein-related information after July 1st, 2025 must be made public, including who classified it, when they classified it, and a summary explaining why. Section 3, report to Congress. After the document release is finished, the Attorney General has 15 days to give a report to the House and Senate Judiciary Committees listing 1. Every type of record that was released and every type of record that was withheld. 2. A summary of all redactions or things that were covered and the legal reasons for each. And then 3, a list of all government officials and politically exposed people who appear in the release documents when, again, none of these names may be hidden for reasons like embarrassment or political sensitivity. So a few words you may still struggle with. A redaction is when a part of a document is deliberately removed or blacked out with black bars before it's shared or released with other people. It's not for editing or style or clarity. It's literally just for legal compliance usually. This is information that can't be released. for safety and privacy. So a lot of times you'll see in a true crime podcast, there'll be police reports where you can see narrative, but maybe the names, phone numbers, they're identifying specific details, especially if they're underage or a victim, will be blacked out or redacted. Those have been redacted not by that podcaster, but by the agency that released those records. Also in here, it talks about how they can't withhold files or stop files from being released because it might impact someone's reputation or cause embarrassment or what they refer to as political sensitivity. So what political sensitivity in this context to me means is, say in these files there are records about the leader of one of our allied countries who we have a lot of financial relationship or benefits with, or who we have strong trade agreements with, or who we have good whatever. Say that the leader of that country is in these files. Now, releasing them could damage our reputation with that leader and then cause sensitivities or disruption in that political relationship we have. So, this is basically saying, even if releasing this information might cause us to have sensitive relations with some of our allies or other countries or other bodies, that's not a reason for us to prevent the release of this information. Now, one additional thing I will add is there's a section in here that talks about investigation. They can't release anything that's under active investigation, and those things that are being withheld because of investigation need to be kind of processed and then released as quickly as possible. So this caveat, I think, is in here because a lot of people ask, why weren't these files released under the prior administration? And the reality is that under the prior administration, they were actively doing some of these investigations, including the investigation into Maxwell. And so they could not release this information because of the caveat of it is part of an active investigation. Just like when the police are investigating a crime in your neighborhood, they can't always tell you the details that they've collected because it could cause the person that they're going to arrest or witnesses to disappear and folks to not talk, things like that. So they could not release those files under the prior administration. That investigation, most of those investigations have come to a close, and so those files should now be releasable, which is why they've been pushing to get this final signature on this piece of legislation to then make this mass release of the files. Now, again, that could absolutely be a reason why you're seeing the current administration go from saying this is a hoax to saying we're going to investigate some of this, because if they pull large parts of those records into a new active investigation, they cannot release them to the public. So, if there's anything else that you didn't quite understand, leave it in a comment, or you can also send me a DM if you feel a little embarrassed, which you shouldn't, and I will explain it to you.